There we go. Hi, everyone. Welcome. Thank you for joining us this evening for the fifth installment of our Own Your Sound, Mastering the Business of Music webinar series. We are thrilled that you all could join us. I see some familiar names, so thanks for being with us for the whole series, as well as some new folks joining us this evening. That's great. Let's dive in. I'm Meredith Badler. I'm the Deputy Director of the Colorado Business Committee for the Arts. And one of our programs is Colorado Attorneys for the Arts. We're one of the co-presenters. And then I'm also joined by our friends from the Colorado Music Industry Alliance. So we are co-presenting this 6-part series. Just some housekeeping items as we get started. We are recording this webinar, so know that these are being recorded. They are being shared later, free and available on CBCA's YouTube channel. We have a whole playlist going. So if you have to leave early, if you've missed a session, if you want to rewatch a session, if you're just coming in on night 5 and you realize there's 4 more of these, please go back. Or if you're watching this on YouTube, hello to you. We're glad you found us. Because we are recording, and just to help us all stay focused on the really terrific content, we're going to ask everyone this evening just to stay muted and to keep your camera off. That helps us all just stay focused and keep the recording nice and crisp. But we do still want to hear from you. Use that chat. I see several folks have already said hello. Introduce yourself. Again, I see some new names and some recurring names, which is great. And that chat is also a great way to ask questions. There will be time at the end for Q&A, but if there's something like super immediate or you just want to say it and hope it doesn't get lost, put it in the chat and we'll capture it there. And just ask you all to be respectful, show up with your best self, support our shared learning tonight. And there is one more session left. So we'll be here, our only one in April. Next Monday, April 7th, will be the final session in this series. So just a quick bit of information about who are the 2 organizations that are co-presenting this series. So as I mentioned, the Colorado Business Committee for the Arts, we're a 501c3 organization. One of our programs of many is the Colorado Attorneys for the Arts Referral Program, or CAFTA. CAFTA at its core is a referral service. So if something you hear tonight or throughout this series makes you go, ooh, I should really hire a lawyer, or I should get a lawyer to draft that contract or protect my copyrights or help me negotiate this deal, we run a referral program here in Colorado to help connect artists with legal assistance. And then we also do consultations and education and webinars like this across the state. And we are also joined by our friends at the Colorado Music Industry Alliance. I know DNA is on, but it's driving. Are you in a good place to say hello, DNA?
I will say what's up. What's up, y'all? Thanks for joining us today. I'm DNA, one of the co-founders of CMIA. And yeah, super excited for everyone to be here today. I'm also trying to get home so I can whip out my notebook. But yeah, I'll be around. So appreciate y'all. Thank you, Meredith. Thank you, Max, for being here for real.
You bet. We are big fans of our friends at CMIA. They've got a lot going on. I'll throw a link to their website in the chat in a moment. But you're not here to listen to me. We are here for this 5th session, which is all about some of these very important contracts. You've heard us talk about various contracts over the course of this series. And this is really about looking into some of those really important relationships and agreements and getting them into writing, what should be there, what you should look for. I'm thrilled for tonight's conversation. I'm a nerd and love contracts. So we're going to hear from Max Haas with Holon Law Partners. He'll be leading us through tonight. content. So I'm gonna stop sharing my slides so we can hear from Max. Take it away.
Thanks, Meredith. And hi, everyone. I'm really glad you're all here to join us for week 5. It's been a great couple of weeks of going through some of the fundamentals of copyright contracts and other legal issues that musicians are dealing with. So tonight we are going to move away from copyrights finally for a little bit. And we're gonna be focused almost entirely on contracts tonight, though you're not completely in the clear, because toward the end we'll talk a little bit about the way copyrights come up in the live performance setting, because I know that's an area that people frequently have questions about. So the 3 main contracts and relationships that we'll be talking about tonight are management agreements, or your legal relationship with your manager, booking agent agreements, and live performance agreements. So we'll get into the details of that in a little bit. Just like with every one of my presentations, first thing I need to tell you is that this presentation is for educational purposes only, and itself is not legal advice. I'm happy to provide legal advice in a one-on-one consultation, somewhere where we have confidentiality and attorney-client privilege, and the setting is right for me to be able to advise you as to what's in your best interest for your particular situation. But this isn't really the setting for that here. So I will probably point out certain things that are, what we like to call best practices in the music industry, but that doesn't necessarily mean that it is the best advice for your particular situation. I don't know about your particular situation, so take this just as education, and then you can always follow up with questions and more details later. So a little bit about me. I am primarily an entertainment and business attorney. I'm also a musician. And I recently started my own music publishing company. I'm originally from upstate New York and have been living in Colorado for the last 6 years after 7 years in New Orleans. I've been working in the music and entertainment industries for basically my whole professional career since graduating law school. I've been a manager, I've been a booking agent, I've been a promoter, played in lots of bands, including some here in Denver. So I understand live performance agreements from a lot of different angles, management agreements from a lot of different angles, what can go wrong on both sides of that type of deal, as well as booking agent agreements, and from firsthand experience, the importance of putting those types of arrangements in writing. So to that point, the agenda is pretty simple tonight. I'm going to give you a brief review of some of the contract fundamentals that we touched on in week 1. Like I said, we're going to mostly skip over the copyright side of things, even though that's been part of the classes for the last 4 weeks. It won't really be a major element of this week or of next week. That probably will come up a little bit more next week than it will today. And so once we do a refresher on contracts, we're going to talk about, I said management agreements in the agenda here, but I think we might actually start with booking agent agreements, and then we'll talk about management agreements, and then transition into live performance agreements and Q&A. I also have a little bit to touch on when it comes to PROs and how they interact with venues and artists who want to play cover songs and play their own songs and things like that. I believe that's something we touched on a couple of weeks ago, and Dave might bring it up again next week, but it's an important point that does relate pretty closely to live performance agreements. So as you might remember, a contract at its most simple level is really just a promise, and it's the type of promise that the law will actually enforce because it follows certain requirements or formalities. Contrary to popular belief, you do not need something to be in writing in order for it to be a binding contract. There are certain types of contracts that legally are required to be in writing, but in many cases, the agreement can be formed even without a writing, or certainly without a formal contract document. In some cases, you may not even have much of a conversation at all, but the party's conduct may imply that there's a transaction that has taken place, and that's what we call an implied contract. In order for a contract to be enforceable, whether it's in writing or verbal or implied, is that there needs to be something taking the form of an offer, as in I will do something for you, and there needs to be an acceptance of that offer. Yes, I accept your offer of providing services to me. That's what we call a meeting of the minds. The parties to the agreement need to be on the same page, figuratively, and in some cases literally, as to what exactly the agreement is. Otherwise, there isn't an agreement. And then it's not enough in terms of a legally binding contract for there to simply be an offer and acceptance. There needs to also be this thing called consideration, which is essentially some form of payment for that offer and acceptance, meaning the parties are bargaining for something. In other words, what I try to describe it best as, the parties are voluntarily giving something up that they would not otherwise be required to give up. So for instance, a very simple contract is, if I tell someone I'll paint your house, they can say, sure, love to have you paint my house, but it's not a legally binding contract until they say, I will pay you money to paint my house. And then that becomes a bargain. This person did not need to give up money, but they agreed to give up money in order to get the services from me. And similarly, I did not need to, or was not legally compelled to paint their house. Otherwise, I had voluntarily agreed to cut out some time from my schedule to go provide these services. And as long as you have that bargain being made by both parties to a contract, it becomes a legally binding agreement. So, why are these so important? Well, the first thing is that at a very big picture level, contracts are really fundamental to smooth operation of business activities. Whether you're a large corporation with lots of different complicated things going on, or an individual artist just trying to protect your rights and make sure that you get paid for the services you provide to other people, having those contracts helps make sure that you do get paid on time, that you have recourse if someone is late or fails to pay. In cases involving copyrights, that you have a clear understanding of who owns what and who's entitled to do certain things with the copyrighted material. And at the end of the day, that type of thing will make it much easier to run your business, because if everything is verbal, nothing is written down, people's memories fade, one side has a different recollection of what the agreement was than the other, it gets really difficult to actually get business done, because you spend a lot of time debating and arguing over what the actual obligations are. And so if you find that the other side is resistant to paying you for the services you've provided, and there's no contract, it makes it that much harder to navigate that situation. Whereas with a contract, it's usually a little bit smoother and easier to flow through these things. Now, in many cases, a lot of businesses are accustomed to using contracts, and so it actually works well to sort of meet them where they are, because they're expecting to have the terms laid out, so that if they have turnover of employees, or someone else moves into a managerial role, and it's not the same person that you originally dealt with, that document is still there to serve as a reference. So you don't need to rely on the individual memory and recollection of specific people. Once a contract is sort of up and running, you both agreed to it, you're moving forward with the services and payment and things like that, the terms of the agreement essentially become private laws. So, all of us in society are subject to the laws that are on the books, the statutes and whatnot, and those we call public laws. But the laws or rules contained within a contract only bind the people who have voluntarily put themselves into that contract. And yet when they do that, it's not an insignificant thing, right? Putting your signature on a document, as one judge famously said, is not merely an ornament. It is there to indicate that you have read and understood what your rights and obligations are in this agreement, and that you are putting your signature there as a way of indicating that you affirmatively consent to those obligations and any recourse or repercussions that might occur if you don't follow through on them. Then the last piece as to why contracts are important is that it just sends a much better professional message. There's lots of situations in the entertainment industry where people are happy to do deals on a handshake or, back of a napkin or something like that. But the reality is that if you show up to a record label, a publisher, a high level venue or promoter or festival, and they ask you for your contract form and you don't have one, or you're not able or willing to provide one, there's going to be a change in the perception. And unfortunately, that's a really important element of the music industry. I've found so many situations where artists have tried to handle things on their own for a while, and they're finding that they're just being ignored or talked to in sort of a disrespectful way, or their concerns aren't being taken very seriously. And then as soon as they hire an attorney or a manager to step in and represent them, the tone of the conversation completely changes. And so, it's not always feasible to have a manager or an attorney at all times in all of these situations, but you absolutely can still improve your overall business practices by having standard template agreements that you use for sync opportunities or that you use for live performances. And when you're the one supplying a professional looking contract document to the other party, they're immediately going to take that more seriously, treat you more professionally, treat you with more respect. And on top of all of that, as soon as they sign that agreement, you then have certain protections and recourse that are spelled out in that contract that you may not have otherwise had if you had just done a verbal agreement or confirmed the terms in an email and didn't really address boilerplate and dispute resolution and things like that. And then the last thing I'll say is that, similar to what I was mentioning earlier about, people's memories fading and whatnot, there can often be lack of clarity and specificity around the exact terms of an agreement unless you put it into some kind of written document. And taking that time of actually sitting with the terms, sitting with the other party, talking through these things will help you really make sure that the obligations are clear and specific. You don't want to have vagueness or ambiguity in a contract because that leads to disagreements later on, right? You may have confusion as to how many payments this company is supposed to make to you, or how frequently those payments are supposed to be made, or what the deadlines for those payments are. And if you don't have it clearly spelled out in a document, that's where people start to bicker and say, well, I already paid you everything in full. And then you have to go dig through your bank records or somewhere else. But having the terms right there in a contract allows you to just refer to the document and then go back to what you were doing. And it avoids a lot of issues that can come about. So in most music contracts, and obviously we've talked a lot already these last few weeks about record deals and publishing deals and sync licensing deals and sample clearance. And the contracts we're going to be talking about today don't really directly deal with masters and publishing in quite the same way. But a lot of the key points in really any music contract are actually very similar. One of the biggest things and most common things that you'll see across all types of contracts is a definition or sort of parameters for what the scope of work is. What services is one party providing to the other? In the case of managers and agents, when we talk about commission or compensation, it's usually in the form of a commission. But again, just like any other type of music contract, you want to make sure that compensation is clearly addressed. Credit provisions, not as much of an issue in this case, but sometimes it might be. Your manager, your attorney, other people might want to be mentioned in the liner notes as, having provided certain services in connection with an album or something like that. Copyright ownership really only comes up primarily in the management setting. I wouldn't say this comes up too much with booking agents or with venues and talent buyers. But, there's a long history, unfortunately, in the music industry of unscrupulous parties, whether they're managers or labels or other people who will try to sneak clauses into a contract that shouldn't otherwise really involve the transfer of copyright ownership and try to take some sort of ownership. And in a lot of cases, managers are one of the first contractual relationships that an artist gets into. And in the case where a manager knows a lot about the industry and recognizes that the artist might not know very much about the industry, they may try to put certain things in this agreement and say they're standard and, you know, everybody in the industry does this or something like that, and try to, you know, get the artist to just sign it and move on without really looking at it critically. So, you know, I just want to flag that here because that's something that, you know, you wouldn't think needs to be looked out for, but you just never really know what's in that contract until you actually read every word. So it's important to look out for that. You know, deadlines are always important. Even if they're not firm deadlines per se, there might be certain time periods laid out in an agreement. Maybe, you know, there's expectations around how quickly the, you know, booking agent or manager is going to start securing work for the band, or what types of preliminary steps need to happen before the manager or booking agent's obligations actually kick in. So you would usually want to address that in the form of a date or some other sort of calculable amount of time. Again, all in the name of clarity and specificity, because if you have ambiguity in an agreement, that's what leads to disputes, which can lead to lawsuits. And to avoid getting to that place at all, it's well worth taking a little bit of extra time on the front end to work out the details of a contract before you put your signature on it, before you're stuck in that agreement without much of an ability to change it. And that way you can set yourself up for the smoothest possible relationship that you can have with that party. And again, you know, I've mentioned this before, but this type of thing, even if it involves hiring a lawyer and, you know, going through some rounds of negotiation, the costs of doing that will always be less than the cost of having to litigate something later on. It is just not worth the money to dive into a lawsuit that could have been avoided by spending $2,000 having someone revise the agreement for you. And that's just a made up number, but my point is that, you know, $2,000 spent on the front end will save you $20,000 2 years later when you have to file a lawsuit. We can get into that in more detail in the Q&A if needed. And then, you know, frequently overlooked provision of a really whole section of many contracts, just because people don't typically understand what it actually means, or if they're putting a contract together themselves without the assistance of an attorney, they don't necessarily know why these sections are so important. But what we typically call the fine print or the boilerplate of a contract, sort of the back half or the back 2/3 of an agreement after you've covered the key terms, a lot of that stuff typically addresses dispute resolution, so that if something comes up, you have a clear procedure and protocol to follow so that you don't compound the problems of disagreement even further by arguing over where to file suit and arguing over whether someone gets attorney's fees if they win. All these details can actually be hashed out in advance. So we would typically have provisions in there that determine, you know, whether you should try mediation first before immediately jumping to filing a lawsuit. If you do file a lawsuit, what state is it going to be addressed and resolved in? Those types of things can, you know, sometimes you won't be able to avoid that initial dispute over the key terms. Maybe one party does in fact fail to make payments as required under an agreement, but it makes the problem a lot worse if you then don't know where to sue them. So you file a lawsuit in a state or court that's convenient for you, and then they drag it out by trying to transfer it to another court or dismiss your case or something like that. Whereas if those types of issues were addressed in the contract ahead of time, it would eliminate their ability to do things like that. So that's an area that, you know, we could get really in the weeds on. We're not going to for right now, but there's a reason that lawyers put that stuff in there. And the idea is to try to have a fairly streamlined process if a legitimate dispute arises that can't be resolved easily. You at least have a procedure you can follow, and that tends to make things a little bit better in that dispute resolution process. And then I just want to circle back up to the top here. You know, way too often I've come across clients who don't realize that they even can negotiate or fully understand what negotiation really means. On the most basic level, negotiation is just revision of the document. Contract can say just about anything you want it to say, provided that the other side agrees. And so it's really a collaborative effort between you and the other party to hash out the details of a contract, which means making revisions, sometimes multiple rounds of revisions, so that it says what you want it to say before you put your signature on it and make it somewhat permanent. Negotiations can be, and when I say revisions, they can be really small things, like requesting a change in how your name is spelled in the credit provision, or making sure that your address is listed correctly. Those are little things that don't really seem like negotiation per se, but it still falls into that category, because the broader point here is that if you don't address it and ask for a change to be made, the other side is not going to voluntarily make that change for you. So even if it's really little stuff like making sure the spelling is correct, or really big stuff like pushing back against the price that they're offering, negotiation is one of those things where you have to make an effort before you put your signature on it if you want this contract to look at least a little bit closer to what you want it to say. There's a lot of situations where a label or a manager or a sync agent or lots of other established companies in the music industry will find an artist that they're really excited about, and they'll send them a contract and they'll say, sign this and get it back to us as quickly as you can. Sometimes they'll even pressure the artist to get it back to them in 24 hours or 48 hours or something like that. And I would say that right off the bat usually is a little bit of a red flag. I understand that parties want to work quickly, but if they really are wanting to work with you in a professional way, then they'll understand that you need time to read through that contract yourself at a bare minimum, possibly also hire a lawyer to review it for you, and then maybe even take it a step further and have that lawyer come in and negotiate it on your behalf, or at least make some revisions. If the other side is resistant to the idea of you doing that at all, that's a huge red flag, and you probably shouldn't work with them. That's just been my experience, that if they're mad about you getting your own legal representation, it means they are trying to exploit you or take something from you that they shouldn't otherwise be allowed to take. So that's usually something to steer clear of. But that being said, if you are dealing with a scrupulous individual or company on the other side, as you work through the revisions and negotiations of that document, it's still a dynamic where they are going to be looking out for their best interests and you are going to be looking out for yours. And the only way that you get certain changes made to that agreement is by asking for it and making sure that you bring it up in those negotiations. So it's this very sort of common misconception I've come across with a lot of artists, that when someone hands them an agreement, that it can't be changed, or that they need to just go ahead and sign it because the company is asking them to sign it. But what I always tell people is hit the brakes. You need to read it and thoroughly understand it yourself, because you are the one who's going to be legally bound to it. And then if there are issues in this document and you don't want to agree to certain provisions in there, maybe you think the term is too long and you don't want to be locked up in a contract for 5 or 10 years or something like that, you need to be the one to speak up and actually change that. And if the other side says, well, we're not willing to knock this down from 10 years all the way to 2 years, but we understand what you're saying and we'll give you 4 years with, the option to renew for an additional 2 years or something like that, right? So you never know how the other side is going to respond when you push back and negotiate. And negotiation does not always need to be a confrontational adversarial process. It can literally take the form of revising a document, making comments on it, asking questions, things like that. And if you're dealing with a reasonable party on the other side, they are also going to treat you with professionalism and respect. And even in the areas that they're not willing to agree, the best negotiations that I've been involved in, they'll explain why they say no. Well, we understand where you're coming from, but we just can't risk investing this much money, but then letting you go after only 1 year, because then we won't have an opportunity to make back our investment. And they'll explain, why they're not willing to agree to certain things, or maybe make a counter proposal to some of your revisions. So really important concept for any type of contract. And I would say that it really comes to light, this concept of negotiation, the most in the types of contracts that we're dealing with here, because these are frequently personal contracts. Yes, there are booking agencies, large companies with a whole staff of agents, and management agencies with several managers who work for them. But in many cases, a manager or a booking agent is just an individual person who's looking to help your band or your individual act. And in those cases, you're entering into a working relationship with another person. You want to make sure that you are as much in control of that relationship as the other person is. And so negotiation and really understanding the agreement you're getting into is a paramount concern in these kinds of things. So just kind of an overview here of who's on your team. And this isn't totally comprehensive. There's definitely other players who would be involved. But as you as an artist develop your career, you will start to sort of build a team around you. And it may include an attorney. Eventually, almost always includes at least a manager. But frequently, as your work expands, your fan base expands, your opportunities to perform at bigger and bigger venues and on bigger stages grows throughout your career, you will probably start adding to that team and having one or more booking agents. You may also have tour managers, road managers, people who are just dedicated to doing your marketing, things like that. And so the team is essentially the different components that help you run your business as an artist. We're going to talk a lot more next week about the overall framework of running a band like a business. But the people that you select to be part of that team are a really important element of that. So just some sort of terminology and orientation here. Booking agent, for the most part, is basically just booking live shows. What I've sometimes in the past called management light, because sometimes you would start out with a manager who is also essentially operating as a booking agent, but then doing a whole bunch of other stuff. And in my experience, I was asked to be an artist's manager immediately out of law school while I was still waiting for my bar results in Louisiana. And I was booking tours. I was helping coordinate a holiday benefit show for Habitat for Humanity. I was helping him get set up on SoundCloud and other streaming services. I was making merch and all kinds of other things. But then there were these other bands that came along and asked me to be their manager as well. And I said, this is way too much work for me, just a single person without an assistant or any sort of staff of my own, to be manager in this sort of full scope way of several bands at once. But there is some of this stuff that I could probably do to help you. And so I offered to be the booking agent for those bands because I had contacts and the expertise with booking shows and things like that. So, a lot of people who do booking and management frequently have some sort of experience with the other as well. Not always, but especially if you're a little earlier in your career and you're working with, a peer from school or somebody that you have met kind of in the music scene and they're looking to help bands out. Those are people who are often freelancers who have experience with a lot of different things. Maybe they've worn a lot of hats in the music industry. But as you grow in your career and you become more established and you're working in the bigger music markets like LA and Nashville and New York, you find that there are, at a certain level of being an artist, these people are very much different role players on that artist's team. And so, there are established booking agencies where those people are only booking agents. Maybe they've never been a manager in their life, or if they did, it was briefly, but the last, 10, 15 years of their career, all they've been doing is booking shows, routing tours, getting artists booked for festivals, things like that. That's really their specialty. And then managers, especially professional managers who have really honed in on that area as their craft, their skill set, they probably know how to do booking. They've probably done quite a bit of booking. But what's more the manager's role is the overall operations of the artist's business. So they're helping out with social media and with marketing, but also with financial management. They might even be directly handling the money for the artist in some cases, or hiring a separate business manager who's essentially the artist's accountant. The manager is also operating in both the live and the recorded world, creating opportunities for the artist, not only in working with the booking agent to line up shows and route tours, but also to make sure that the artist is maximizing their earnings from streaming and getting a YouTube and visual presence out there in the world, helping develop the artist's brand, things like that. And then, of course, there are other roles. We don't have time to talk about all the ins and outs of these, but as you get to a high enough level in your career where you're touring, consistently, let's say, 100 days a year or more, you have vans or buses that you either own or rent on a regular basis, you probably have a much bigger team than just your band that comes on the road with you. You might have techs, you might have roadies, you probably have a tour manager or a road manager who is essentially the person in charge of that piece of the operation. They make sure that all the hotels are lined up. They make sure that everybody is in their hotel rooms, by curfew, that they're awake on time for the bus call the next morning, that they're at the venue on time for load in and sound check. When you're just starting out as a band, you are doing literally all of the stuff yourself. But as your operation gets bigger, it becomes really important to make sure that those types of logistics are being handled, because it's frequently too much for you as the musician to be writing the songs, recording the songs, practicing, rehearsing, resting properly, getting your voice ready, getting your body ready for your shows, doing all the things that you need to do to make sure the music is good, and also worrying about all the logistics. So, obviously it's a lot of up and coming artists' dream to have this team because it would make their lives easier, even on a smaller scale. But usually the way we see this develop is that, these other smaller roles on the team don't really come about until essentially there's enough money to go around. So, it really comes down to how much you're grossing per show or per tour that dictates whether you can actually build a budget to bring in staff and things like that. Booking agents and managers are not part of your road team. They are part of your core operations as a band. So we're going to get into the details a little more specifically about what a booking agent agreement looks like and what that relationship typically looks like. And then after that, we'll move into management agreements. And then we'll talk about live performance agreements and working with venues and buyers and promoters. So I broke these out just kind of in terms of an outline of the major clauses that would be addressed in these agreements. I don't have like a sample booking agent agreement to show you right now during this presentation, but that is something that I do have. So if anyone is in need of a template agreement or something like that, it's something that I can provide. I'm sure Dave has things like that as well. And I'm sure lots of CAFTA volunteer attorneys do too. But what you need to know are these key terms, because even before you put the formal agreement together, and certainly well before you sign it, you're probably going to talk through these terms with your agent first. And if you're an agent, same thing. You would probably want to make sure you get some clarity on these things before you just dive into booking shows for a band. That being said, the reality is that lots of people in the music industry will dive into these types of relationships before they actually have a contract in place. Maybe they've had one or two verbal conversations about some of these terms, and maybe they have the intent to get into a written agreement at some point. But in my experience, it is fairly common that people will sort of touch on some of the key points and then just dive right into working with each other. And then maybe they get a written agreement in place later on, but sometimes they don't. So my recommendation is to take the time to work this out ahead of time. Contrary to what a lot of the music industry makes you think, there is no rush. If you're at a point where you're ready to hire a professional booking agent, who's going to take your career to the next level, it's well worth getting these terms worked out, getting a written agreement in place first, so that there's no confusion or disagreements or hurt feelings or misunderstandings around payment, expectations, things like that later on. And I can speak to this from my own personal experience, and also as an attorney, I've handled, the preparation of these agreements, and I also currently dealing with a lawsuit between a booking agent and a band. And the key problem in this lawsuit is that there was not a written agreement that clearly spelled out what the terms were. They talked about it. They occasionally exchanged some text messages about it. But now that we're in this disagreement and the agent thinks that she's been underpaid for the services she provided, it's really difficult to work out what exactly the band understood their obligations to this booking agent were, because we don't have this written agreement that clearly spells everything out. So it's a common issue to not have the agreement in place. It doesn't always blow up in your face in something that turns into a massive lawsuit, but it's still easier to operate with these terms written out in agreement, even if a lawsuit never comes about, because again, the document essentially serves as a reference. If you're ever confused or forget the details, you just go back to the agreement and that tells you what the deal is. So, the agent will either be independent or working with an agency. And in some cases, your agreement is with the agency directly, and they will, select an agent to work with you, or perhaps you already have a relationship with a particular agent, but because of their employment situation with the agency, they're required to have the agency bound to the agreement instead of themselves personally. But in any event, it'll be, that on one side of the deal, and the artist or the individual person who is responsible for the artist enterprise will be the party on the other side. So in cases where you have a band, if you're not incorporated as an LLC or a corporation, you may have to all sign as individual band members, since you'd be a partnership in that case, or designate one of your members to sign on behalf of the band. But if you are an LLC or a corporation, you would typically sign as your LLC or corporation. So commission is the main way that agents get compensated. Typical industry standard is 10 to 15% of revenues derived from the opportunities that they directly secure. So they will go out and source offers from venues and promoters and festivals, and then they'll take them back to you or your manager. You approve them or reject them or ask to negotiate some terms, and eventually the agent will get to a point where the venue is willing and ready to confirm. And once you lock that deal in, that's a deal that the agent has earned their commission on, because they were directly responsible for getting that in place, and it was confirmed as as a performance that is actually going to happen. Offers that don't get confirmed are not something that the agent should get paid for, obviously. But there sometimes are sunset clauses. I would say that a reasonable sunset clause directly addresses opportunities that the agent did in fact secure for the band. But what a sunset clause does is addresses what happens to the agent's payment even after you stop working with them. And in some cases, if the agent or the agency is providing contract, that sunset clause might be a little bit more expansive than an artist would typically want it to be. So just something to look out for, that those sunset clauses or the way that the commission is defined can sometimes be a little more expansive than what an artist is comfortable with, where it'll say, anything that's an opportunity that we created, whether or not we were directly responsible for booking it, is still something we should get paid for. And so that's one of those things that artists would typically push back against. Frankly, even as someone representing an agent, I might discourage them from being too overreaching in those situations, but that's partly because I'm a pretty artist biased person. I'll admit that any day. Um, and then, the services are fairly limited. A booking agent is not there to do everything for you. They are there to primarily make you money through performance opportunities. So the most common would be, booking shows at venues, routing tours, or booking locally for wherever you're based. A good agent will also have relationships with that create opportunities at private parties. They have, a well-connected agent will also know several festival buyers directly, so they'll be able to submit you for festivals, even the ones that are a little bit more difficult to get access to. And then sometimes, depending on the scope of what their connections are or what the band is specifically looking to do, an agent might also know publicists and producers of TV shows and can book, a live TV performance or something at a radio station or something like that as well. It's one of those things where, all of these things on this list really are points in the contract. But like I said earlier, these are things that should be a conversation with the agent so that you understand what is the extent of their expertise and connections. What are they actually going to be able to do for you? Because you don't want to go into a relationship like this expecting that they're going to, bring you a windfall and get you booked coast to coast and do all these things when the agent themselves, never offered or promised that, right? So getting clear on what the expectations are on both sides is really important for avoiding disputes down the road. The term of a booking agent agreement, I would say never less than 6 months. And even then is pretty rare that I would see one that short. But in some cases, they recognize that the artist is, not ready for a long-term commitment. They want to test each other out, see how things go. So you might see a somewhat shorter term that, renews for another 6 months if things are going well. Most common would probably be more of like a 12-month term or longer if you're a more established artist, because the bigger the artist, the bigger the venues that the artist is performing, usually the longer in advance you need to get those opportunities secured. So, the booking agents for Beyonce are booking 3, 4, 5 years in advance. You're not going to really be effective with a 6-month term on that type of arrangement, right? So it all just sort of depends, again, on what the artist is actually looking to do and is able to do that will dictate the scope of those services, and probably also have an impact on the term of the agreement. Copyright ownership should pretty much never be an issue with a booking agent because they're there to book live performances. They shouldn't be touching your masters or your publishing at all. So there's really no reason for them to have any sort of ownership or even a license to your copyrights, except some very limited license that allows them to share your music with buyers, share your name and image and biographical information, because that's what goes into a standard pitch that booking agents would make to venues and buyers, right? So they will have that limited permission that allows them to do their job, but they shouldn't be involved or touching your masters or publishing at all. These contracts are usually pretty simple, right? I mean, a booking agent agreement is not usually a very complicated thing. In my experience, these really shouldn't be more than 3 or 4 pages, and in some cases, they're only 2 pages. It doesn't need to have a ton of complex legal language in there. It really just needs to have the key terms, maybe a few things that address dispute resolution just in case anything goes wrong. And that's pretty much all you need. A record deal has a lot more going on, and that's why we see 20, 30-page record deals. But booking agent agreements usually don't involve much. Now, a couple thoughts just on the compensation side, because this is where discussions really need to be somewhat fine-tuned, is you want to be really clear on how exactly your agent is getting paid, not just the commission percentage, but what that commission, what that commission is calculated from. And so the 3 most common ways that commissions are calculated for booking agents that I've seen are either net receipts, gross receipts, or I would say in somewhat rarer situations, gross walkout potential. So, if the agent is booking a show for you where the artist is just getting paid a flat amount of money, a guarantee, then there's the question of net versus gross shouldn't really be much of an issue. But really what it comes down to is the agent's commission will usually just be calculated as a percentage of what that guarantee is. Everybody knows what the band is going to get paid. And so the agent has a very clear understanding of what their portion of that should be. In the situations where an agent is booking shows that are ticket based or some other, attendance based payment, in some cases, an agent will want to calculate their commission on the maximum sellout value of that show, because in their mind, they're creating the opportunity for the band. And ultimately, it's on the band to promote it and get their fan base to come out and make it a success. And ultimately, the agent shouldn't feel, or at least this is the theory, the explanation they provide, the agent doesn't want to feel like their compensation should be contingent on things that are totally out of their control. They booked the show, they created the opportunity. If a show has, capacity for 400 people at $20 a ticket, then the agent wants to make sure that their commission comes off that, maximum possible earning of $8,000. And if the band falls short of that, then that's not the agent's fault, right? So it's not always one or the other of these things. My experience is that gross receipts is probably going to be the most common thing that you see come up. But it depends on, again, the level that you're at, the types of shows that you're playing, and how established and professional the agent is. The more established agents might push for the gross walkout potential figure instead of gross receipts. Net receipts, I would say, are probably not as likely to come up, though it is obviously, what the artist would appreciate in most cases, where basically the agent's commission only comes out of the amount that's left over when expenses have been taken out. And in some cases, the venue will take out certain expenses, or the band has certain costs and expenses related to a show that are unavoidable and are occurring every single show. So again, it all comes down to expectations. If the agent understands all these nuances and recognizes that the net receipts is still a large pot of money, so that their commission is still going to be, a reasonable one, they may be willing to agree with that. But I would say that most agents are probably looking for something that's calculated off of gross, because they don't want to be penalized for expenses that are not related to them or their work. So one last thing on money with booking agents is that in some cases, the agents will have a buyer pay a deposit. And if that's the structure of the deal, then agents will typically have the buyers send that deposit directly to the agent first. And the agent will then take their commission from that initial deposit and then send the rest to the band. And then the remaining balance just gets paid directly to the band when they get to the venue for the show. In other cases, and this is probably where I would say is happening with smaller bands, people who are just starting out or kind of on their way up, it's usually a little less formal than that. And in many cases, maybe it's not the type of show or venue or artist where a deposit is getting paid ahead of time. And if that's the case, then usually the money just gets paid, the full amount at the show and gets paid directly to the band. And then the band is responsible for sending a portion of that to the agent. Obviously, that requires a decent amount of trust. Actually, both of these things require a decent amount of trust. But for the agent, if they are going to agree to that kind of arrangement, then they need to be sure that the band is going to properly pay them on time for their cut of the money from those shows, or that they have some sort of system worked out. That can be somewhat of a sensitive subject, but it has to be addressed to make sure that everybody is paid fairly. Even if you don't like the agent or you think they're doing a bad job, if they earn the commission, the artist is not usually justified in just arbitrarily arbitrarily deciding to withhold that commission unless there's, some sort of direct breach of contract that's happening that does in fact allow that. But in most cases, you need to make sure that everybody is getting paid properly. So let me pause for a second and just take a look at the chat here and just see if there's any important questions or things that have come up. I don't think so. Cool. Okay. So we are going to move on to management agreements. So similar framework, I would say. Usually it's either an individual person as the manager or the management agency or management company that is binding itself to the agreement. And then compensation is commonly in the form of a commission as well. Now, the difference here is that the scope of services that a manager is providing is much, much broader. And so accordingly, the compensation is calculated off of a much broader source of revenues. So manager is not only involved in creating live performance opportunities, deciding, when and where the band should go on tour or working with the band to determine that, but also maximizing streaming revenue, maximizing sync opportunities, maximizing opportunities for the artist to appear in TV shows and movies, which also are a source of revenue, but way for the music to get more exposure. TV performances, appearances on high-profile, morning news shows and things like that. They can bring a lot of visibility to a band. Directly managing social media or bringing in a social media manager to handle that. And on a bigger picture, the managers are involved in helping shape and refine an artist's brand, or if the artist is looking to kind of reinvent themselves, a manager is usually right there with them, helping them figure out the how of doing that, right? And so, broadly speaking, a manager's compensation is a little bit higher of a percentage than a booking agent, but it's also calculated off of a much bigger pool of money. So it's derived from, revenues of all sorts that the manager is involved in creating. So if the manager is part of your team before you release your album, then the manager is going to get a cut of revenues that come in from your album. If the manager was involved in shopping you around to record labels and landing you a big record deal, then the manager is going to get a cut of the money that comes in from that record deal. That might mean a piece of the advance and a piece of the back end money later on. So manager, in many ways, even if not, officially or formally partnered up with the artist in a partnership agreement or in an LLC or something like that, even on a sort of informal way, a manager is functionally the artist's business partner. The artist has the vision, has the creations, makes the art, decides what they want, certain things to be, but then the manager helps them execute it, helps provide feedback, helps do market research, and then also brings it to market for the artist, right? So really wide range of services, and what goes hand in hand with that is that the term is also typically going to be a little bit longer than a booking agent agreement. So again, 12 months is probably a basic deal where they're just getting to know each other. But for something a little bit more serious, you might see a 2-year term or 3-year term, or maybe you'll see a 1-year term with 2 1-year option periods that automatically renew if the manager hits certain financial milestones or something like that. Copyright ownership should also probably not be that much of an issue in these types of cases, but history says that there is a risk here. Historically, going back to the 30s, 40s, 50s, 60s, there have been many music managers out there who have decided to take advantage of, an artist that doesn't know anything about the music business and just knows how to sing. And the manager will sneak certain clauses into their agreement that says that they control the artist's masters, or they're the exclusive administrator, or they take a 50% ownership or something like that. And I say historically, but every once in a while, even in 2025, you do see things like that come up every once in a while. There are people out there who are absolutely operating as essentially predators in the music industry, who are trying to take advantage of artists that don't understand this terminology, that don't know how to negotiate deals, who are willing to sign something without reading it, and they try to make their money that way. Those are not the types of people that you want to be working with as a manager. You want somebody that you can trust, somebody who can be a business partner, who you're trusting with your money, with your career, which as an artist essentially means you're trusting them with your life and your livelihood in a lot of ways, right? And so, I would definitely keep an eye out for copyright language in a management agreement, because frankly, it shouldn't be there in most cases. But if it is there, then you want to make sure you understand what it says, that you have an opportunity to discuss it with the manager. And that, again, just like everything else, that there are clear expectations around what's going to happen with that. Sunset clauses are probably more common in a management agreement than they are in a booking agent agreement. Again, because the services they're providing are much broader and more extensive in the artist's career than a booking agent's are. And so sunset clauses will frequently extend for 1, 2, or maybe even 3 years after the relationship between the artist and the manager ends, and will either be more narrowly defined as direct revenue streams that the manager helped create for the artist, or could potentially be drafted a little bit more broadly and essentially give the manager opportunities to keep making money off of just opportunities that they created. And the argument typically goes that after 1 or 2 or 3 years of a manager working with an artist, the artist is usually in a much better position in their career than they would have been without that manager's help those previous years. And so the justification is that the artist wouldn't even be able to get in the door of certain opportunities if it weren't for the manager bringing them to that level in the music industry. It's debatable. I don't want to spend too much time on that specifically right now, but I'm happy to discuss it in the Q&A. But it's one of those things that should be part of the conversation. It might be a little nuanced to have as part of your very first conversation with a potential manager, but once you start putting a document together, especially if the manager already has a standard form that they use, you want to make sure that you're reading and understanding the entire agreement, but especially looking out for that sunset clause, and really understanding how long is there going to be a financial tie to this manager even after you stop working together. I'd say that in a reasonable artist manager relationship, that a sunset clause is not a sort of per se unreasonable thing to have. I think that there is a justification for managers to have some sort of sunset clause there. But where things really need to be looked at closely are the term of that sunset clause. How long are they going to continue extracting money from the artist, and what is the scope? Are we talking about just certain very specific revenue streams and the others fall off, or are we talking about everything? That's where the discussion really needs to be had and really address a balance that works for both sides. Similar with booking agents, just a note on money. The artist-friendly version of a manager's commission will be defined as net receipts, whereas the more manager-friendly commission will be based on gross receipts. Now, just like any other situation where you're dealing with gross versus net, net means deducting certain expenses first before paying out the commission. And a manager, in many cases, probably won't want an extensive list of expenses to be deducted, because then the pot of money from which their commission is calculated gets really small, and then they're not really getting paid much of anything at all for doing an enormous amount of work for the artist. On the flip side, gross receipts can sometimes feel a little oppressive to an artist, because it means they're paying the manager first before they even have an opportunity to pay any of their other bills. And they might have studio fees that need to be paid, or van rental that, absolutely needs to be paid, or else they're going to send it to collections or something like that. And so there isn't like a perfect balance there. It's part of the negotiation to figure out what's going to be acceptable to both sides. But one compromise that I could just throw out here right now for y'all to think about is that you could come up with a hybrid or sort of a limited version of net that basically has a very specific defined list of expenses that are calculated solely for the manager's commission. There might be other expenses that are taken out after the manager is paid, but you could say for purposes of this contract only that our definition of net is this very, very specific list that the manager is comfortable with, and then they'll get paid their commission, and then the band can use whatever's left to pay their other bills. So all it takes, like everything else, is just some discussion, asking questions, making sure that everybody's on the same page. But these are, really the important elements of a management agreement. So you want to make sure that you're taking your time with this. And then the last major contract that we'll talk about today is live performance agreements. This can be between an artist, or if the artist has a company, I would say it's probably more common that the artist company is actually entering into the agreement, and then a buyer on the other hand. And we use the term buyer because that's essentially what they're doing. They are purchasing the artist's services for a specific date and time. And so, most commonly, the buyer is somebody who works as a talent buyer at a music venue. If the venue doesn't have a full staff, then it might be the owner of the venue who does all the booking. Sometimes a place that is also a bar will have their bar manager or some other trusted person handle the booking there. But whoever it is, it's usually an entity of some sort that is specifically purchasing the artist's services for a specific date and time. And so you'll have live performance agreements with festivals, with independent promoters who are putting on shows at a third party location. And in some cases, if you're playing a private party, the person throwing the party is the buyer in that case. And so these agreements are usually pretty straightforward. I've typically done live performance deals as like 2 to 3 page documents for my clients. And I wouldn't say that they need to be, really skimpy and light on details, but it is a pretty straightforward transaction. You need to have information on the compensation. You need to have information on when the band is expected to perform their services. These are usually pretty specific things that you don't want to just leave up to a TBD or, we'll figure that out later. You want to be clear on when you're expected to be there, because if you miss that date or you're late by a certain amount of time, that could be seen as a breach of contract. So it's really important so that you understand that you're not inadvertently breaching the contract because the buyer had an expectation around your performance schedule and didn't communicate that to you. You want to make sure that everybody is super clear on what those performance expectations are. And then you, on the flip side, want to make sure that it's really clear what the compensation is. It's not one of those things that you want to just leave up to chance or rely on, people's memory. What I've done as a booking agent is make sure that that information is at least very clearly spelled out in an email thread with the venue. But ideally, we take all that information from the email thread and we drop it into a contract and ask for a signature so that we do have that authoritative contract document that actually reflects the full details of that agreement that we have. Now, depending on the leverage that the artist has, you can also demand certain technical requirements. And I would say that this is sort of a somewhat moot point if you're playing at legit music venues or festivals or things like that, because of course they're going to have those things. But what you'll find is that even in the situations where they're the ones providing contract document, they will actually usually be very detailed and thorough in explaining what it is that they are providing for you as the artist to make your performance a success. So they'll specify that we have a stage that has this dimensions and we have a sound system that's capable of doing X, Y, and Z, and that sound system includes subwoofers, and we have certain lighting that's going to, look professional and whatnot. Those types of things will frequently be in a live performance agreement to be super clear on what the mutual obligations of the parties are. And then, of course, you'll have production details too. You not only want to need to know what time and date your performance is, but you also should have a clear understanding of what your set length is. You don't want to get into a situation, and I say this as a musician who's been in this situation, where you think you're playing for only 90 minutes, but then the buyer expects you to play for 3 hours. If there's that type of misunderstanding, then you're going to have problems getting paid any extra money for that additional performance time. But if you have clear understanding of what the set length is supposed to be on the front end, then that can be part of your negotiations over price, right? You can be very clear with people and say, well, for a 90-minute set, we're not going to take any breaks, and we'll give you, 90 minutes straight of music for this amount of money. That's what it's going to be. But if the buyer comes back and says, oh, well, we actually want you to play 2 sets and it's part of a wedding, so we'd love to have you guys come play 1 hour between 5 and 6 and then come back at 8 and play for 3 hours, that's a very different situation, right? Now you've got musicians who are going to be performing for 4 hours total, but at this event for 6 or 7 hours or more. Now it starts to change the price, right? You can't just keep everyone there for only $100 a person. Now you need to make sure that all your bandmates are getting paid properly for how much time and labor is being expected of them. And so that should dictate the total price, right? So having those production detailed as part of this contract is very closely linked to what that price should be. You may also have details in here around whether a deposit is required, and if so, when that deposit is due. Sometimes you have situations where there may be 2 deposits, like one at the time of signing, one 30 days before the show, and then the final balance on the day of the show. Lots of variations on how that can be done. But again, that type of thing should be put into writing in this agreement so that everybody is clear on what you're getting paid and when those payments need to show up. If you have an agent booking this show for you, this is where your contract, your live performance agreement, may actually specify that the deposit, or maybe the first deposit, is to be sent to the agent, and then the second payment is to be paid directly to the band, right? You can get into all those details in a contract, and you can put as much specificity in there as you need. And then, of course, many of us have heard of riders. We all dream of being able to have extensive riders one day. But, depending on the type of show that you're playing, the venue might be providing a hotel room for you and your band. It might be providing additional compensation in the form of meals. You might have certain specific hospitality requests for the green room. I had a band from New Orleans that I brought out to Colorado a couple of years ago. And when they played certain venues, they asked for, a bottle of tequila in the green room. And I'd actually never worked with a band that had a rider before. So I was a little bit surprised, and the venue was like, oh yeah, no problem. So it's, again, one of those things where if you don't ask, the venue's not going to give it to you. But if you do ask, you might be surprised at what kinds of things they might actually be willing to agree to. So that sometimes will be like an attachment to the main contract, or could be part of the contract itself, just sort of a personal preference. And then one of the last 2 points that are some of the most important have to do with money, of course. If there are going to be cancellations or the risk of cancellations, or if we had all had a crystal ball in January of 2020 and knew that a whole bunch of shows were about to get canceled, we might have what we call a force majeure provision in there. We want to be really, really clear on whether the band is still getting paid some portion of the money, even if the show gets canceled. And if that's the case, what are the timelines on that? So in some cases, you might have cancellation provisions that have multiple tiers to them, where it says if the show is canceled, more than 90 days before the performance date, that, no fee is owed at all. But if it's canceled within, the last 30 days before the show, then a certain portion of the fee is owed. And if it's canceled, less than 48 hours in advance, then the full amount is still owed, right? That's just an example. But the reason we put cancellation provisions in live performance agreements is because it can really, really mess with an artist's income if shows get canceled and there's no recourse or repercussions at all, right? And so it's one of those things where venues might be a little resistant to this or might be difficult when you try to bring something like this up. But at the end of the day, it's really about fairness. And the band is blocking off time on their schedule for a show that they expect to be paid for. If that just gets pulled out from under them with no time to adjust and find a new venue or find a different, work opportunity for themselves that week, then it's one of those things where they should still be paid because they don't have any other way to make up for that, right? I'm sure that's something that people can debate, but that's something that I always make sure to build into live performance agreements when I'm doing those on behalf of artists. And then settlement is, the details of how the artist is actually getting paid, right? So we want to know, when is that payment happening? Sometimes an artist might specify that it needs to be, a check or cash put in their hand before they step on stage that night. And I'm not getting on stage unless I see that money. In other cases, it's one of those things where the check is coming immediately after the artist finishes their set. That's something that the venue will typically push for instead, because they want the assurance that the artist actually will get on stage and play before they fork over the money. Related to that, if the compensation is based on ticket sales or door receipts or anything like that, then you want some accountability and some transparency, right? So in some cases, you might be allowed to have your road manager in the room while they're counting the money. That way you have sort of a representative of the band there as your eyes and ears, helps sort of keep people honest. Or if you're not allowed to have somebody in the room, then there should at least be an opportunity to see the real numbers and make sure that you can verify that the check is correct, that the amount is correct, that the door receipts are actually what the venue says they are, and things like that. At the bare minimum, there should be a settlement sheet provided after every show. I've played several shows at a lot of venues around Denver, and some venues will give you a very thorough settlement sheet where they'll explain, we took out this much for security, this much for sound, this was the gross amount we pulled in off the door, but then we took a ticket per ticket fee or something like that. And you see in detail where all the money went. And it may not be that satisfying of a bottom line for you as an artist, but at least you have that transparency and you understand what the costs were that went into that show, and you understand that the venue is being honest about how that money is being allocated. So that pretty much covers those three major contracts. I want to just touch briefly on PROs because this comes up with live performances pretty often. So we talked a little bit about PROs over the last couple of weeks in connection with publishing. And we'll probably touch on them again next week, because as just, part of collecting your all available revenues as an artist, making sure that you're signed up with PROs as a songwriter is an important way to make sure that you're capturing those revenues. But let's talk about this from the venue side for a minute, because this is an area where there's a lot of confusion and lack of understanding. And it's partly because the PROs themselves are not always great about making it clear to the outside world what exactly they're obligated to do. Many businesses that function in the live music industry are not otherwise operating in the music industry, right? They are not learning about masters and publishing in a deep way, the way artists and managers are. They are just running a bar or they're running a restaurant, and they love having live music there, but they're not somebody who's staying up on all the ins and outs of the music industry, right? So they might not necessarily understand how the public performance right to musical compositions works, or why these licenses are required, or who the money is going toward, and things like that. And then what only compounds the problem is that the representatives of the PROs are essentially salespeople, but they are salespeople armed with the threat of copyright infringement, which is a very strange dynamic to be dealing with, because typically a salesperson is just trying to sell you something that you can take or leave, and is no big deal if you say no. They're going to obviously try to get you to say yes, as any good salesperson should, but there's no real repercussion if you say no. But with the world of PROs and public performance music licensing, that's not really the case. If you say no, but you're using music in your establishment anyway, then you're committing copyright infringement. So it's this very strange dynamic, and it doesn't always make for the best, I would say, working relationships between venues and PROs. But it's an important area, and it's something where artists often get caught in the middle. So I want to take some time to break this down. So as a songwriter, you sign up with a PRO because you know it's the way to capture revenues from your songwriting. Every time your song gets performed publicly, whether that be streaming, live performances, radio play, background music at a restaurant or a doctor's office or something like that, those are all counted as public performances of musical compositions and earn you, as the songwriter and the owner of the publishing, a royalty from that. Now, if we didn't have PROs, then you as a songwriter would have to go around to all of the different businesses and establishments that use music in some way, either as live music or as recorded mechanical performances of music on a sound system. And you would have to go and get a license individually with all, or grant a license individually with all of these different venues in order for them to have permission to perform your song. Because you're the copyright owner, you get to control how public performances are made. But that's obviously really impractical, and that's why the PROs first came about. ASCAP being the very first one, BMI came along 20 or 30 years later. CSAC started in Europe and Canada, and then eventually came to the United States. And then in the last 10 years or so, or really 12 years, we've had the development of 3 additional PROs. So we now have 6 PROs in the US. They all have slightly different catalogs of music. And it's a very complicated situation because if you want to access the music of one particular catalog, you need to get a license from that PRO. And if the music you're looking for is not controlled by that particular PRO, then you have to go and get licenses from one or more of these other PROs. Now, let's take it back for a second. On the artist songwriter side, you can only sign up for one. So you affiliate yourself with ASCAP or with BMI, or maybe with AllTrack, one of these newer services that's come along, and you give them permission to control your public performance rights in your musical compositions. It's a non-exclusive license, so you still get to do things with your public performance rights yourself if you want to. And in many cases, there are reasons that you as the songwriter should still have some direct control. Let's say you're going and doing a private performance somewhere, or you're performing on a TV show or something like that. If you're in a position to grant these licenses directly yourself, then it's makes things a little bit easier. But because there are millions of businesses out there that use music, the PROs are essentially this clearinghouse. So they represent millions of songwriters who have all granted them the permission to go out and allow third parties to make public performances of their songs. So in order to do that, venues and restaurants and coffee shops, radio stations have to go to the PROs and get what's called a blanket license. You can't go and cherry pick specific songs and just get a license for 5 songs. The only way they do this is by getting a blanket license to the entire repertoire that that particular PRO controls. And then the type of blanket license that that venue or business needs to get is based on how they use music in their establishment. So if they're primarily a live music venue, they will pay based on the fact that they have a certain number of performances of live music per week, certain capacity and maximum potential ticket revenue per show, and then the fees are calculated based on that. But if you're a radio station, the calculation and the use of music is a little bit different. So you get a radio station license instead of a live music venue license. And then in some cases, they offer much more limited scope licenses for places that do music very infrequently or only a small number of times throughout the year. And in a lot of cases, these PROs also offer licenses for independent promoters who can then put on shows at a wide variety of establishments. And as long as they have the license and report the music being performed at these shows, then the venues don't need to worry about getting their own license. And that's actually a very common way that a lot of big venues here in Denver operate. The venues themselves, like Red Rocks and Mission Ballroom and some others, don't actually have their own PRO licenses, but instead they work with promoters who rent their venue space, and then the promoters hold the PRO licenses, and they account for all the music that was performed at those shows. So, as an artist, how and why do you get caught in the middle of this? Well, the most common thing that I've seen is that venues that do not have any PRO licenses at all will state this somewhat incorrect thing on their website or on a piece of paper on the wall of their venue that says, you can't play covers because we don't have a BMI license. Well, that is technically true, that if you play covers and they don't have a license, that it is an infringement of the copyright owned by those songwriters. But it's not really the artist's responsibility. It's actually the venue's responsibility to have a license in those situations. The venues will sometimes try to make it the artist's problem and the artist's responsibility, but the copyright law actually specifies that it is ultimately the responsibility of the physical establishment where music is being performed to have the proper licensing in place. Now, that could mean that the establishment works with a promoter who's renting the space, and as long as they feel confident that the promoter is doing everything right and has the right license in place, then they don't need to worry about it, and the artist doesn't need to worry about it. But smaller venues who aren't really as knowledgeable or savvy about these PRO issues will sometimes put this information up there and make it seem very oppressive that, an artist is going to be very limited in what they're allowed to play there. Now, there's one problem with that, which is that a lot of independent artists are also affiliated with a PRO. And so even playing their own original music in that bar implicates a PRO blanket license. Now, it's a little bit less complicated if you are playing your own original music, because you, as the songwriter and the owner of that copyright, are doing the performance as well, right? You're making the performance, so there's really nobody you need to give permission to, per se. But it is still this weird situation that is frankly more hostile to artists than it needs to be, and more hostile than what the copyright law even allows. But what it really comes down to, contrary to what a lot of venues think, is that it is, in fact, their responsibility to either have a license or work with a promoter or some other entity that holds a license and is going to manage the music at their venue for them. The fees can be expensive if you're the type of place that is doing, live music every night, or even as much as 1 to 2 times a week. It can get pretty expensive pretty quickly. But if you're only doing music infrequently at your venue, and you ask the right questions, or you work with an attorney who understands how this stuff works, you can get the PROs to quote you prices that are much more in the 3-figure range. I've actually been having a lot of conversations with PROs over the last couple of weeks on behalf of a client who runs a venue and has had questions about this. And there's a lot of misconceptions out there that are not necessarily easy to get to the bottom of unless you spend time talking to someone at a PRO in fairly high level detail about the ins and outs of their licenses. If you are going to play covers, that's a situation where the PRO licenses really do need to be there. And the reason for that is that you don't control the copyrights to those songs, right? Some other songwriter or publishing company owns those copyrights. And if they are affiliated with a PRO and they have authorized these PROs to issue public performance licenses on their behalf, then the venue needs to have that license in place in order to be properly getting permission and compensating that songwriter for those covers to be performed. Assuming that's in place, the artist can do pretty much whatever they want. They can choose what their set list is going to be. If it's a legit music venue that has all the right licenses in place, and there won't be any restrictions or problems at all, and you can play whatever you want to play. Now, there is sort of an enforcement issue too, which is that many songs controlled by the PROs aren't necessarily registered for copyright or weren't registered in the right way that opens them up to the possibility of statutory damages. And so to pursue lawsuits over, a couple of songs being performed at a venue without a license means spending tens of thousands of dollars over what might have just been a couple $100s in lost licensing revenue. And so it's not frequently worth the PRO's time or money to go after every single violation. And so you may find that there are a lot of venues out there operating not in compliance with this PRO framework, partly because they don't know about it, or partly because they think it's too expensive, or partly because they've heard from other venue owners that the PROs are all bark and no bite, and it's just not worth spending the money on something that has, no downside anyway, right? So those venues, I would love to educate them a little bit more and get them to a place of being as savvy about these things as artists and managers and other people who work full-time in the music industry are. But ultimately, it doesn't happen across the board, and there are plenty of venues that do have the proper licenses in place. And so, it's one of those things where you might want to ask a couple questions, but depending on the situation, it might not be worth ruffling feathers either. But I've also found that the places that are the most resistant to paying for PROs also tend to be places that aren't necessarily as artist friendly. Places that are willing to pay for PROs are doing it because they understand why they're doing it. They understand that they are part of this music industry ecosystem. So it can be a bit of a touchy subject. It can be one that brings out a lot of strong feelings from venue owners and certainly from artists and artist representatives. But it's an important issue and does sometimes come up in that live performance agreement context, because you may find that sometimes venues will try to sneak in a clause that says it's the artist's responsibility to get the PRO licenses or something like that. And that's frankly just a little bit crazy. I don't think that artists should ever be put in that position. But again, it's one of those things where as long as you're reading the contract thoroughly and understanding it, you should at least notice when something like that jumps out at you. So be on the lookout for that. So somewhat shorter list of recommended resources here. Since the things that we talked about today were not strictly copyright issues per se, I'm not putting the Copyright Office information and other stuff up here, but there is a book that I tell almost everybody is well worth investing in. It's a book that was strongly recommended to me when I first started law school and has come up many, many times in my career. It's called All You Need to Know About the Music Business. And it's written by an entertainment attorney in LA named Donald Passman, who's been doing this for 40, probably close to 50 years now. And he revises the book every 2 to 3 years and comes out with a new edition. So he's keeping up on changes and evolutions in the music industry. I'm sure at this point there is an ebook version of it somewhere, but the hard copy I feel is well worth it because it kind of serves as a reference you can go back to. It's one of those books where you can read it cover to cover and just get a big, broad overview of the music industry, but you can also go back to certain chapters and say, I need a refresher on how management deals work or how publishing deals work. And he's got dedicated chapters to each of those things. So highly recommended. Online, there's a blog called Ari's Take, maintained by a guy named Ari Herstand. He touches on a wide range of things, including PROs, streaming royalties, other things like that. Can't say for sure how much content he has on contracts and live performances, but he is just overall a wealth of information in the music industry. So his blog is highly recommended. And then, of course, as you've noticed, there are some entertainment attorneys who enjoy teaching and sharing information. So you can usually find some helpful music lawyers in your area or in your network somewhere who will be able to answer some questions for you, in addition to providing advice and frankly, all of my consultations include some element of education as well. So attorneys can definitely be a good resource here. And then here's my information. You can scan the QR code if you want to set up an appointment or follow up with me. I've also got my email and phone number provided here for you to copy down directly. And we have time for questions. I see a lot of things in the chat, but I haven't looked at what they are. And so if anybody has any questions, now would be the time to talk about that. So let me go back through some of these questions here. All right. All right, starting with the top. What are some examples of expenses taken out pre-manager? Well, so what this question is referring to is that there are two alternate ways of calculating a manager's commission. Sometimes you might have a net based calculation, sometimes it's gross. So if you have an arrangement that involves net, then it means you're taking out certain expenses before you pay your manager their commission on the stuff that you're bringing in. I don't know that there is a standard approach to this, but just thinking off the top of my head, one example of an expense that you might deduct prior to paying the manager is maybe some hard costs associated with distribution of your record. So let's say you have a $50 a year fee for United Masters or Symphonic to keep your music up on streaming. Obviously, your manager is going to get a piece of your streaming revenues, but maybe you want to make sure you're covering some of your basic expenses like your annual United Masters fee or physical production costs, things that are sort of a one-time hard cost where the manager understands that is sort of part of the nature of doing business. Those might be the types of expenses that a manager would be willing to agree to in a net deal. Again, there isn't like one right answer here, so it really just comes down to what your discussion and negotiation with the manager or the artist, depending on who you are, what that conversation yields. And then whatever you agree on, just make sure you confirm that in writing in the agreement. Next question, in the lower level indie circuit of booking venues and shows, is it customary for the artist and booking agent to send an offer first when booking shows, or will the contract be initiated by the talent buyer? In my experience, it starts off with email. Usually it's a couple rounds of emails to hash out some of the details or figure out what date exactly is available. But once you get the date, the pay, the set length, some of those core details figured out, you would usually, say something like confirmed in writing in that email. And then I would say that if you want a contract and you're in this sort of lower level indie circuit, it is almost always going to come from the artist. But I would say that it's usually best, just from a practical standpoint and a deal flow standpoint, to get agreement on the key terms first and not just start by dropping a contract in front of them. You want to make sure that they know where you're coming from with all of that, that they've already agreed to the important parts of it, and they're not just surprised to see a contract show up in their inbox. With bigger venues, you may not necessarily find a contract coming from them, but you would get like a formal offer sheet that will have all of the details on the money, the set length, the show time, other bands on the lineup. If it is a ticket sale sort of thing, they might even do the calculations on what the gross potential is. But again, that won't be a contract per se. That's just an offer sheet, which usually you respond to by saying, confirmed or accepted, or sometimes they might even have a place for you to sign on the offer sheet to indicate acceptance. But that's not going to have usually all the other terms and conditions that would typically go into a proper contract. So depends again on what you're needing as an artist and what you're looking for. But I would say at the indie level that it's almost always going to need to come from the artist in order to have something like that in place. Next question, is the live performance agreement usually the agreements at the artist company? do with their booking agent? No, I would say your agreement with your booking agent is your booking agent agreement. That is going to have a different set of terms that dictates the working relationship between you and the booking agent. And then the live performance agreement is the agreement between you as the band and the venue or the buyer. Sometimes the booking agent will be the one to generate and send the live performance agreement, but still have a space for the artist to be the one actually bound to it. And in some cases, I've seen this with at least one agency down in Miami, they actually sign the performance agreement on the artist's behalf. And they essentially guarantee that the artist will show up for their performance and all these other things. I would say that most agencies probably don't do that because that takes on a significant amount of risk. The agency then becomes liable if the band is a no-show or cancels on them or things like that. And that's not usually a position that booking agents want to put themselves in. But in most cases, I would say to ensure that, you know, all of the proper parties are correctly bound to the agreement, that it's typically between the artist on the one hand and the venue or the buyer on the other hand. Next question, if I'm with a PRO, can I grant my own license to a venue that doesn't have a blanket license? Yes, you can grant a license for your own material that you control the rights to. Generally, when you affiliate with a PRO, the deal that you enter into with the PRO is a non-exclusive one. So yes, you are giving the PRO permission to license out the public performance rights to your songs on your behalf, but you're not doing so on an exclusive basis, meaning you are also still allowed to go out and grant licenses to the public performance rights to your original compositions. But again, you need to be the one in legal control of the copyrights to be authorized to grant that sort of license to a PRO, and also to be able to grant a direct performance license to a venue. Next question, how does the PRO find out and know about what songs were performed or played? A couple of different ways. Historically, before the internet, before, you know, rapid communication, the PROs employed large staffs of people who would actually go out and survey radio stations, venues, doctors' offices, other things like that, and actually, you know, do enough direct surveying and in-person investigation and things like that, that they'd be able to collect enough data to get statistically significant sample sizes, and then be able to extrapolate from that what songs are being performed and how frequently and all of that. So that's sort of the old school way that they used to do it. I would say to some extent they do something similar to that to this day, in that they sort of keep tabs on venues, social media pages, and other things. And if they see videos of bands performing at a particular space, they will make note of what songs are being performed. If they recognize well-known covers that they know are part of their PRO's database, they'll probably make note of that. And especially if they notice that, you know, there's regular videos indicating that performances are happening every week or every night or things like that, you know, to some extent they are going to be paying attention to the specific songs, but the bigger thing that they're going to be looking at is whether this venue is utilizing live music or recorded music on a regular basis and doesn't have a license, because then that tells the licensing representative at the PRO that they need to reach out to that venue and make sure that they are licensed. Because ultimately it is this weird thing where they are a salesperson armed with the threat of copyright infringement. It's a very unique position to be in as a salesperson, but because PROs represent songwriters, it is in their interest and in their constituents' interest to make sure that these venues are not just committing widespread copyright infringement all the time, right? So the last way that they track specific songs is actually a somewhat newer innovation that at least ASCAP and BMI have developed. I'm not sure if the other PROs are doing this, but it's called setlist submissions. So if you as an artist are also a songwriter and you have your own original music registered with the PRO, and you're performing your own original music on a regular basis, and maybe you're mixing in a couple covers here and there. ASCAP has a program called On Stage, and BMI has a program called BMI Live. And both of these systems work very similarly to another, where you as a writer signed up with whichever PRO can then activate ASCAP On Stage or BMI Live, whichever PRO you're a part of. And you can create and save set lists. So if you're playing the same or a very similar set list every show, you can actually have a pre-saved set list in your account. And then you can go into ASCAP On Stage or BMI Live and report your shows. And what happens there is it actually gives you, as the artist who's also a writer, an additional revenue stream from your own live shows. Not only is the venue paying you for your labor and time of being there in person and performing, which is essentially what your performance fee is, but then because the venue has a PRO license, they will also, the PRO will also pay you your proportional share of those license fees for performing your own songs during your set. So it's a way to make a little extra money through your PRO if you are also a live performer. If you're not a live performer, then you're not going to sign up for this piece of it, but other artists might be playing songs that you've written, and they might be adding them to their set list and then submitting those. So when you're an artist and you sign up with ASCAP On Stage or BMI Live, you need to enter the information about what venue you performed at and what date. And if the venue doesn't come up in the pre-populated list, then it generally means that they do not have a license at all. If they do show up in the list, then it doesn't definitively answer the question of whether they have a license, but it does show that they are in ASCAP's database, which means they had a license at some point in time or do in fact have a license now. And so when you then submit your set lists and you report to ASCAP that you played a show at this particular venue at this particular date and time, you're also sending them a list of the songs that you played. And so ASCAP has firsthand direct reporting from you as the performer that these specific songs were played at that venue at that time. And so if the venue doesn't have a license, but the artist went and submitted a set list anyway, it actually can sometimes flag venues for the ASCAP and BMI licensing people and say, hey, you know, artists keep submitting set lists for this venue, but we actually don't have a license with this venue. Maybe we need to get in touch with them because clearly they are hosting live music on a regular basis, right? So a lot of different methods for how they figure out exactly what songs are performed. And sometimes it's the artists who are giving them that information directly. Next question, closely related to this, are you able to explain or show us how PROs generate their payout rates for registered performances? I don't have the exact formula or calculation. I'm not sure that they even make that formula publicly available. But what I do know is that the way people are paid out from PROs generally is a very complex algorithm that factors in basically artists' proportional market share. And they also do direct surveying of radio stations and other things. They get cue sheets from TV stations that actually submit very specific lists of what music was performed in, you know, the shows that were streamed or broadcast on their station. They get cue sheets from radio stations that show exactly what songs were played and at what times in a weekly period. And then the PROs in the back end do their calculations and pay out the various songwriters in accordance with their sort of proportional share of that total pie of money. If you are doing ASCAP On Stage or BMI Live and you're reporting your own songs, your own original songs, obviously you're not going to get paid from the PROs for performing covers. The songwriters and publishers of those songs will get that money. But anything that's your own original music, you will get paid directly for that. Several years ago, one of my clients gave me some insight into what she was getting paid from her ASCAP On Stage set list submissions, and it seemed to work out to approximately $1 per song per show. And so if you're playing a lot of shows and you're playing your original music on a regular basis, you're probably going to see a much better royalty rate from your own performances of your own original songs than you would see from general streaming payouts or radio station payouts. Because when you're competing with all the other songwriters who are on the radio, who are on the streaming platforms, your market share, unless you're a really, really big artist or songwriter, your market share is probably going to be comparatively pretty small to the Taylor Swifts and Blake Sheltons and, you know, Kendrick Lamars of the world. And so those rates will be a lot lower. But when you can actually verify that it's yourself performing your own songs, and the PROs sort of know that that's more trustworthy and that they can pay you more directly from that. And usually, if I'm understanding things correctly, that money is getting paid basically directly out of the revenues that are coming in from that particular venue's blanket license fee. I can't guarantee that that's actually what's happening, but basically from the PRO's perspective, there's a lot more direct accountability there because they know they're getting however many hundreds or thousands of dollars a year from this venue. And if you are one of, you know, only a couple dozen artists to have performed there, then the PRO can kind of more justifiably say that you're entitled to a piece of, you know, this specific license fee, basically. So I hope that helps answer their question. Another question down here, can you explain when to sign up with Songtrust? Songtrust collects revenues that are related to streaming and other online and digital uses of your music. So I would say that if you're going to work with a company like Songtrust, that you sign up with them either right before releasing your music or shortly after you release your music, so that you can capture as much as possible from the streaming side of your music. And we're talking about difficult to collect foreign royalties and other types of royalties that are not collected by PROs, Sound Exchange, or the MLC. So Songtrust is a private company, actually part of a much larger company called Downtown Music. And they are not really involved in live performance stuff at all. They are only going to be collecting these very sort of niche, difficult to find, difficult to collect type royalties. So typically I would say if you're going to use them, sign up before you've released any music. That way they're part of your team from the beginning. But, you know, you can always sign up with them later and they can work to, you know, go back and collect older royalties if needed. And obviously there's going to be limits to certain things, but, you know, they can still work with you even if you're jumping in after your music's been released. The next question is a big one and very commonly gets asked in connection with management arrangements. Can you talk more about when would be a good time to get a manager? What should you have going on as an artist to feel like you've gotten to that place? Well, this is a little bit of a tricky question because there isn't necessarily one right answer per se, but generally I would say that, you know, if you're just looking for someone to kind of help juggle all the things that you have going on, that you might not quite be at the point of needing a manager, but you might need an assistant or sort of a staff member or something like that. In my early days, fresh out of law school, I had people ask me to be their manager when really all they needed was somebody to write emails for them because they either didn't want to or they felt like it was too difficult for them. And I totally understand that perspective. There's lots of artists that just do not understand or want to handle the business side of things much at all. But at the same time, a manager is much more than just an extra set of hands or an assistant. And so if all you're looking for is somebody to basically help manage the workload of sending emails and getting things going, then you're definitely on the path toward needing a manager, but might not be quite there yet. And what I would say is really the right time to have a manager is when you're at the point where there are more business opportunities to capture than you're able to handle on your own. You need somebody who is ready to be a business partner, who can go out and be your representative in the world and make deals happen, or at least bring you opportunities. And so I guess a somewhat simpler way of saying this is if all you're doing is booking shows, then you might not be there yet. But if you're booking shows and trying to get stuff going with sync and trying to build a national brand for your music, and you want to explore, partnerships with brands and endorsement deals and things like that, where it's more than just needing someone to send emails for you, but you really need someone who's going to help strategize with you, that's when you're at the point where it's a good time to get them in. Now, that all being said, the grain of salt or the caveat that I would put on that is that there are lots of situations where you as an up and coming indie artist want to just sort of have a teammate through the development and growth of your entire career. And we've seen a lot of examples of this where people get partnered up with a manager who maybe is a friend or a family member or someone who just really believes in you and your career. And they might not be a professional manager per se, but they are willing to do anything and everything they can to help grow your career and help bring you to the next level as an artist. And that's the type of thing where I would say you don't need to necessarily wait around. If you've got somebody like that in your corner who's ready to be part of your team, then go ahead and start working with them. But if you're doing a lot of stuff on your own anyway, and you're looking for more of an established professional manager, they are not going to want to spend the time or resources on an artist who isn't really ready to really get things going on all cylinders in their career. The manager who's a professional manager is going to have a lot of contacts already, is going to be able to open doors for that artist almost immediately. And so they're not going to be ready or willing to work with an artist until there's a demonstration that there's some real money coming in, or that there's really strong potential for good money to be coming in. Because again, if everything is commission based, they need to make sure that your gross revenues are high enough so that their commission is something that's actually reasonable compensation for them. So I know it's a bit of a fuzzy answer and it's not really a one size fits all kind of situation. But I can say that from personal experience, being asked to be someone's manager when really they just need an assistant is not always the best way to start a working relationship. And so you want to make sure that when you're asking someone to come onto your team as a manager, that you have a vision for what you want them to do, and you're going to be able to really put them to work and put them to use in that full capacity as a manager. If you do just need someone to kind of help be an extra set of hands, there are interns that might be an option. There's lots of college students that are eager to learn about the music industry. There are people fresh out of school who are eager for an opportunity to be a manager or a booking agent, where they don't necessarily need the same types of things that a full-blown established professional manager would need. And so there are a lot of different ways to approach that. There also is something of a misconception in the industry that once you select a manager, that's your only manager, and that's definitely not always the case. There are some situations where someone has the same manager for 10, 15, 20 years. There's even the rare artists who have worked with the same manager their entire 30, 40, 50-year careers. But more commonly, you're probably going to have 2 or 3 managers in your career, if not more. You'll have somebody who kind of helps you get established, gets you up on that sort of first tier of your career. There's going to be somebody who kind of brings you to the next level. And then once you're really big, you might need somebody who knows how to handle world tours and international TV appearances and things that your first or second manager just wasn't actually equipped to do. So there isn't always like one right manager that's going to solve all your issues for you. You might have a manager who's good for this next 3-year phase of your career, and then you might need to upgrade to somebody different after that time period. It all it can vary a lot. So moving on to the next question here. do you have an opinion about BMI going to a for-profit business? Does that make them less advantageous for songwriters than ASCAP? I don't really have a strong opinion on that because I don't know a ton of information about what the actual impacts of this change will be. For everyone who doesn't know the context here, ASCAP and for a long time, historically, BMI were both organized as nonprofit organizations. ASCAP is still a nonprofit organization. And one of the things that comes with being a nonprofit is that there's a lot more financial transparency because they are legally required to provide that kind of transparency. Every nonprofit's tax return is a special form called a 990 that can actually be publicly viewed. So you can see a nonprofit's profits and losses and expenses and all sorts of other things. And along those same lines, ASCAP likes to boast that it pays out a very significant portion of the revenues that it collects to its songwriters because as a nonprofit, they take only about 9% as an administrative fee to cover all their overhead as an organization, which may not seem like a lot, but when you consider that they're collecting billions of dollars in revenue in royalties, and they have major offices in Nashville and LA and elsewhere, that 9% is actually going a pretty long way. BMI a couple of years ago announced that they were getting investment from a private equity firm and converting from a nonprofit into a for-profit corporation. Part of that conversion involved paying out dividends to all of the songwriters. And I'm not sure if that payment has actually gone out yet, but they basically promised to share with all of the songwriters the profits and the benefits from this new private equity investment money that they were able to secure. So that's sort of a short-term thing that there's, that money, that sort of extra money going out to songwriters. But I don't really know what the long-term effects of BMI going private will actually be. We just haven't really seen the details come out yet. Last I checked on this a couple months ago, the deal still hadn't officially been closed yet, so it's still a little bit up in the air as to what exactly is going on with that. Historically, the only real difference between BMI and ASCAP is that BMI was free for songwriters to sign up with, whereas ASCAP charged a fee. And then one other difference between the two, which is still true today, is that if you sign up as a songwriter with BMI and you don't have a publishing company, BMI will pay you both the writer's share and the publisher's share of those public performance royalties that they collect. ASCAP will only pay the songwriters the writer's share and only pay the publisher's share to publishers. So it forces you as a songwriter to also either create a publisher account on ASCAP or affiliate with a publisher in order to capture both sides of that public performance money. But that is a little bit less of an issue these days because ASCAP recently changed their pricing and now they are also free for songwriters. And I believe free if you do a combined songwriter publisher registration all at once. I don't remember exactly, you'd have to double check the website. Longer term, if people are concerned about, private equity money getting involved in a music company, if they're concerned about transparency and accountability potentially changing with BMI converting to a for-profit entity, I would say those are legitimate concerns, but we don't actually know how they're going to play out. So it's hard to say for sure. I personally signed up with ASCAP years ago, and it's pretty difficult to switch. So I'm, not planning on changing that anytime soon. But I've worked with people who are signed up with both. Also Alltrack has been making a lot of moves lately, and I have started to recommend that to people more recently. It's definitely worth checking out their website and contacting them to get some more information. But for a lot of intents and purposes, BMI and ASCAP are pretty equivalent in terms of how they do things. And I just answered Jamie's other question about the publishing and writer splits. So yes, BMI does still allow songwriters to get both the writer's share and the publisher's share. ASCAP still does not. So with ASCAP, you do need to create both the songwriter and the publisher account to get both pieces of that if you're a self-represented songwriter. So I hope I answered all the questions. If anyone has any other follow-up questions, feel free to email me or get in touch with Meredith and she can pass the questions along. But all my information is up here on the screen, so please feel free to reach out whenever you'd like. Thanks a lot for attending. Really appreciate you all.
Yeah, great questions. Thank you so much, Max. Awesome information. And I'll wish everyone a good evening. Thanks for sticking with us. And again, thank you. Thank you. Thank you.
Of course.
Good
See you
night.
all soon.